In this video, we will complete our look at the seller's remedies, where the seller has the goods and the buyer has breached by examining two less typical but conceptually more difficult measures of damages available to the seller: lost profit damages and the contract price. So let's start with the first of these, the seller's lost profit damages under Section 708, subsection 2. Subsection 2 says that if the market-based damages available to the seller are inadequate to put the seller in as good a position as she would have been if there had been full performance by the buyer who breached, then the correct measure of the seller's damages is the profit which the seller would have made from the buyer's full performance of the party's contract. So essentially, subsection 2 says that the seller is entitled to damages equal to its lost profits, but only where the usual market-based damages would be inadequate to fully protect the expectation interest of the seller. Unhelpfully, Article 2 does not explicitly identify the circumstances where that would be true, where the usual market-based damages available to the seller are inadequate to fully protect the seller's expectation interest. But a number of courts have addressed this issue, and the most common circumstance in which this provision has been invoked by the courts is where the seller is what is called a lost volume seller. What do we mean by a lost volume seller? By a lost volume seller, we mean a seller who has a theoretically inexhaustible supply or inventory of the goods to sell, and who continuously attempts to engage in the sale of her goods to customers with the aim of selling as much as possible. So the basic test for whether a seller is a lost volume seller is whether the seller could have and would have sold to other buyers additional goods, goods identical to those the seller was supposed to sell to the breaching buyer under the contract that was breached. Where the seller is a lost volume seller, the buyer's breach does not mean the seller now has additional goods to sell to another buyer in a subsequent resale transaction. Instead, the buyer's breach means the seller has now lost the potential to profit from its sale of goods to the breaching buyer. Because, but for the buyer's breach, the seller would have had the benefit of both its contract with the breaching buyer and any other subsequent contracts the seller might make to sell identical goods to other buyers. Therefore, in the specific context of a lost volume seller, it would be inappropriate to use any of the seller's subsequent sale transactions or even a hypothetical sale transaction to offset the profits the seller was poised to make from its breached contract with the breaching buyer. Because absent the breaching buyer's breach, the seller would have benefited from both contracts with the breaching buyer and all subsequent sale contracts the seller might make with other buyers. The classic example of a lost volume seller is a new car dealership, which has a theoretically inexhaustible supply of new cars that it can order from the manufacturer and continuously engages in trying to make sales of those new cars. So imagine a new car dealership contracts to sell a new Honda Civic to a buyer. The moment the ink on the party's contract has dried, the buyer repudiates the contract and refuses to pay or take the car. A moment later, another buyer comes into the dealership and contracts to buy that very same car for the very same price. In that case, using resale or market-based damages as the measure of the dealership's damages would mean the dealership would be entitled to nothing in damages as a result of the first buyer's breach. That is because the dealership was able to resell the same car at the same price, which after all was the market price for that car. But that can't be right. That can't be right because it fails to account for the fact that but for the breaching buyers repudiating the first contract, the dealership would have sold two cars, one to the breaching buyer and one to the subsequent buyer. Stated differently, the dealership would have profited from both sales. Now compare the new car dealership to me, trying to sell off my old beat-up car. Am I a lost volume seller? Think about it for a moment. The answer has to be no. Why? Assuming you contract to buy my car at one price, and then you have second thoughts and repudiate your obligation to buy, and then I find another buyer to buy my old car at the same price. Unlike a lost volume seller, I only have one old car to sell. Therefore, unlike a lost volume seller, I could not have benefited from both sales. I can only sell my old car once. Stated differently, if you had not breached your obligation to buy, I could not have engaged in the resale. Your breach is what made my resale possible. In this case, it makes sense to limit my damages by offsetting the proceeds of my subsequent resale from the contract price that you had agreed to pay me under our now breached contract. Now we have a sense of when Section 708 subsection 2 applies. Now let's consider how the damages are actually computed under Section 708 subsection 2. Unfortunately, it is quite complicated, because lost profits are only the starting point for the measure of damages under 708 subsection 2. By lost profits, we would typically mean the amount the contract price, that is the price the seller expected to get paid under the contract, exceeded the seller's total cost of performance. And if we think carefully about the seller's total cost of performance, the seller's cost of performance will have two components. One is a variable cost, that is the cost the seller incurs in performance of the contract, the cost the seller would not otherwise incur but for the contract. For example, the seller's cost in purchasing raw supplies or parts to manufacture goods required under the contract would be an example of the seller's variable cost. The other component of the seller's total cost would be the seller's fixed cost, or overhead. In contrast to the seller's variable cost, the seller's overhead is the cost the seller would have incurred in its ordinary course of business, even if the contract had not existed. For example, the amounts the seller pays for rent of its facilities or the wages it pays to its employees would be examples of the seller's variable cost, costs that the seller would have incurred in any case, regardless of whether the contract had been made. But Section 708 subsection 2 allows the seller to recoup a reasonable amount of its overhead as damages. So as we said, subsection 2 begins with the seller's lost profits as only the starting point for measuring the seller's damages. In addition to lost profits, the seller is entitled to recover that portion of its overhead that is reasonably allocable to the breached contract. Stated in another way, Section 708 subsection 2 measures the seller's damages as the difference between the contract price under the breached contract and the cost the seller would have incurred in performing the breached contract, that is, the seller's variable cost. Now, we could stop here if the seller has not started performing at all under the breached contract, if the seller has not already incurred cost in performance of the contract that the buyer breached. But if the seller has already started performing, that is, if the seller has already incurred cost, then Section 708 subsection 2 allows the seller to recover those reliance costs as damages as well. The rationale is, if there had been no breach by the buyer, if the buyer had paid the seller the full contract price, the seller would have recouped these reliance costs incurred in performance of the contract as part of the full contract price. But because the seller is not getting the full contract price, we have to compensate the seller for its unreimbursed reliance costs, so those costs do not get deducted from its lost profits. Finally, note the statute also says the seller's lost profit must reflect a credit for proceeds to the seller from any resale. This is widely understood as a mistake in the statutory language. That's right, it's widely accepted that this statutory language should be ignored. After all, the whole point of 708 subsection 2 is that any resale of the goods by the seller does not compensate the seller for the profits it lost because of the buyer's breach. The whole point is that but for the buyer's breach, a lost volume seller would have profited from both its sale to the breaching buyer and any subsequent sales. So to make things nice and complicated, this language is simply ignored. If the lost profits have you a bit confused, you'll be grateful to know that our final measure of damages for the seller is a bit more straightforward. The final measure of the seller's damages provided by Article 2, where the seller has possession of the goods, brings us back to where we started this module. Recall, we started this module by examining the seller's remedies where the buyer has the goods. And in that context, we noted that where the buyer has accepted but refused to pay for the goods as required by the party's contract, the seller's primary remedy is damages equal to the contract price for the goods. That's the scenario addressed by Section 709 subsection 1a. But that same provision also contemplates an identical measure of damages, that is the contract price, in another scenario, one in which the seller is in possession of the goods. Specifically, under subsection 1b, where the seller has the goods identified to the contract, that is, the goods are already made and designated as the ones that the seller would sell, but after the buyer's breach, the seller is unable to resell those goods at a reasonable price, either after making a reasonable effort to resell or where circumstances reasonably indicate that a resale would be unlikely, then the seller is entitled to recover as damages from the breaching buyer the full contract price under the party's breached contract. When is this situation most likely to apply? Under what circumstances will goods not be readily resellable? As suggested in the excerpt from Foxco Industries versus Fabric World in your reading, the goods may not be readily resellable because, most commonly, the goods were specially manufactured or custom made specifically for the buyer who breached, and therefore may not be readily suited for the needs or desires of other buyers. But there can be other scenarios where subsection 1b might apply. For example, where the market for the goods is seasonal and the relevant season has passed, so the seller is unable to engage in a resale. Or perhaps, due to broader circumstances, the market for the goods has dried up. Imagine, for example, a contract for the sale of a large shipment of smartphones that have since the time of the contract become outdated, obsolete, and therefore unsaleable. Or to take one final example, my favorite example, imagine that after much salesmanship, I finally get you to agree to purchase my old beat up car. But sometime afterward, before you actually pay me and I hand you the keys, you understandably have second thoughts and decide to back out. The truth is, my old car is not a very good car. In fact, it's pretty much worthless, and I can't find anyone else who wants it. So after you breach, I can't engage in a resale. When the seller is unable to resell, the other measure of damages won't work. We can't use a resale transaction as a basis for determining the seller's resale damages. After all, we're talking about a situation where the seller is unable to resell. And the seller's inability to resell suggests there is no market for the goods. So there is no reliable market price to determine market-based damages. And the final measure of the seller's damages, the lost profit damages, is also not appropriate. Remember, the measure of damages is based on the assumption that the seller could have and would have sold the same goods to someone else. But where there is no other buyers for the seller's goods, that assumption is inapplicable. So because the other measures of the seller's damages are inadequate, the seller is entitled to the contract price, plus damages for incidental losses. Note, however, that under subsection 2 of 709, where the seller seeks damages against the buyer for the contract price, the seller must hold the goods for the buyer. The rationale is that by seeking the contract price from the buyer, the seller is effectively asking the buyer to perform its obligations under the party's contract. Stated differently, the seller is essentially asking for specific performance by the buyer. So to come back to our example one final time, if I sue you to pay the full contract price for my car, at least I have to hold and give you my car when you pay me. So that's it. That concludes our look at the seller's remedies in the event of the buyer's breach. And it also concludes our course. To briefly recap, in this video, we looked at the two final measures of the seller's damages where the buyer breaches and the seller is in possession of the goods, two measures that apply only in specific scenarios. And that also brings us to an end of our studies of Article 2 sales. Congratulations on making it all the way through. Take care and never stop working hard toward your goals.